Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Soon to adjourn. God save the Constitution and His Honorable Court.
Well, welcome to the First Court of Appeals. We're here today to hear case number 01-19-00387-CV. The case is styled AC Interests LP, formerly American Coatings LP, versus the Texas Commission on Environmental Quality. This oral argument will have 15 minutes for each side. And I understand that the appellant has asked to reserve 4 of those 15 minutes for rebuttal at the end. And so I'm going to ask the appellant's attorney, Mr. C. William Smalling, to introduce himself. And then I'll ask the appellee's attorney to do the same. Ms. Kelly E. Billings-Ray. Go ahead, Mr. Smalling.
My name is C. William Smalling. I'm the attorney for AC Interests, formerly American Coatings LP.
Thank you. And Ms. Billings-Ray?
Yes, Your Honor. Kelly Billings-Ray here on behalf of the Texas Commission on Environmental Quality.
Thank you. I'll turn it over to you, Mr. Smalling, just to confirm you would like to reserve 4 of your 15 minutes for rebuttal. Is that correct?
Yes, Your Honor.
Very good. I'll turn it over to you for your presentation.
Thank you. May it please the court. Texas jurisprudence, third limitation on actions, paragraph 122, which has been submitted as Exhibit 3, Bates number EX3-001, states, tolling of limitations period during pendency of legal proceedings generally, when a person is prevented from exercising their legal remedy by the pendency of legal proceedings, the time during which they are thus prevented should not be counted against the person in determining whether their limitations have barred their right. The legal remedy and legal impediment may include the situation where the outcome of an initial case determines the viability of a subsequent cause of action. This rule cites Pollard versus Hanshin, 315 Southwest 3rd, 636, which in essence restates the basic rule. However, in the rules, the case states the limitation time period was told during this case was an appeal in the court the last time. As a general rule, where a person is prevented from exercising his legal remedy by the pendency of legal proceedings, the time during which is thus prevented should not be counted against him in determining whether limitations have barred this right.
Mr. Smalling, do you have any cases that would apply those principles to a mootness situation as opposed to tolling the statute of limitations?
All I have is the cases that toll the statute of limitations.
Okay.
But it seems to me the level, the statute of limitations exceeds the stringency of a regulation standard. Therefore, it seems to me the cases regarding statute of limitations would trump a regulation. That's.
I got a quick question, counsel. I noticed in that exhibit that you referenced, it's one of the cases that's cited is the Four Brothers Boat Works case that's cited in that texture reference that you just mentioned. And that case indicates that the rule that you just articulated is a limitations rule that the Supreme Court of Texas says is expressly limited to attorney malpractice cases in a limitations context. Is there any authority that you have that again, would apply it to this type of situation, to a mootness case and outside of a attorney malpractice situation?
Well, Cabot versus Amsler references Williams versus Pounds, 48 Texas 141, which states there's a stronger reason why the statute of limitations did not run against appellant after July 14, 1917, at which time the limitation was completed against him. On July 14, 1917, cause number 23679 was heard on the motion to dissolve the temporary injunction, and the following decree was entered therein. All parties are enjoined from transferring, encumbering, or otherwise disposing of the stock of McGregor Mill and Grain Company, and the McGregor Mill and Grain Company is enjoined from paying dividends on said stock until final hearing of the cause on the merits. The final hearing on said cause was had February 23rd, 1920. Such being the case, had appellant filed suit at an earlier date to recover the dividends paid to Amsler, the milling company could and doubtlessly would have replied that they were not permitted to pay such dividends until adjudication occurred.
Is that is that a limitations case also?
Pardon me?
Is that a limitations case again that you're reading to us?
It sounds like it's a court order that the court limited the time that the appellant could pay dividends.
Are you aware of, is there any exception to the mootness doctrine that might be applicable here?
Just the cases that I've cited. It just seems to me, in all fairness, if you're stopped from pursuing any kind of administrative action because of court proceedings, I mean, that should toll the regulation time, the running of the regulation time. Actually, this is the emission credits. If you type in emission credits in case law and Westlaw, the first 10 hits you get are AC interest versus TCEQ. I mean, we're the guinea pig on emission credits.
So the best authority that you have right now to give us is the cases that are cited in oral argument exhibit number 3 in that texture third annotation. Is that correct?
Yes, yes.
Okay. I was curious. I noticed that looks like the facility fire occurred in July of 2010. And that ACI then filed suit or then sought to certify their ECRs in October of 2013. What transpired between those two dates?
Well, between October 3rd, 2013, the rule has a provision that the TCEQ wrote us back and said we have a problem with such and such. Can you clarify this? And so we kept resubmitting the application, hopefully trying to comply with their request for information And so we resubmitted the applications on October 2013, November 2013, and April 2014. Finally, after April 2014, it took them another 7 months to review what we had submitted, and they finally turned us down in November of 2014, and at which time that was right before Thanksgiving. I worked day and night to try to get this lawsuit written up and got it filed on December 10th of 2014.
I think the question was about the time between 2010, when the fire happened, and when this effort started in 2013. What was going on during that time frame?
Well, I've got an answer to that as well. The fire happened in 2010, and the plan was the company was wanting to, at that time, was wanting to rebuild the plant, and so there was what we thought was a quick way to reauthorize the plant called a permit by rule, and TCEQ initially told us we could use the permit by rules to get the plant reauthorized to build quickly. With the permit by rule essentially states, if you build something that's the same as it was before, then you're okay to go ahead and build. But then TCEQ recanted and said, well, no, you got to get a full-blown permit. So that's what we did, and it took them from roughly November 2011 to May of 2013 to go through the permit rigmarole, red tape to get us the permit. So we didn't get the authorized emission credits until we didn't get the authorized to emit emissions until May of 2013. And then the company decided, well, we'll just go ahead and shut down the facility. And so we applied for emission credits.
All right, Mr. Smalley, thank you. Were there any more questions before we go on to the appellee from the other justices? No. All right, Mr. Smalley, thank you. We'll see you again in just a little bit. At this time, we'll ask Ms. Billings-Ray to join us for the presentation by the appellee.
Yes, Your Honor. May it please the court. The issue presented here is mootness, and this appeal should be dismissed because these emission credits are no longer viable. The timeline for the lifespan for a certified emission reduction credit is 5 years. Now, appellant AC Interest submitted their—
true for offsets? I thought that was only true for the sale process.
What the statute says, Your Honor, is that it is the lifespan of the credit to bank it is 5 years. Is that your question, Your Honor? I'm sorry.
I thought that the ability to offset extended beyond the 5 years.
My understanding, Your Honor, and is that once it's banked, it can only be banked for the 5 year period. That's the way I understand it. So if it hasn't been, but if it's been offset, that's right, Your Honor. So once a facility uses that credit to offset it, then it remains. So that will remain for the other facility using that credit. Does that answer Your Honor's question?
I think so.
And to go back really quickly, appellant AC Interest submitted their application requesting certification of emission credits 4 times. And 4 times, the commission was unable to certify the request because AC Interests either could not or did not provide the required information. So after 4 submissions in November 2014, the TCEQ issued its final denial to AC Interests, and AC Interests sought judicial review. So in the final denial letter, the commission explained that the emission reductions could not be verified. And because AC Interest had continued to provide conflicting information throughout those applications, and the commission couldn't determine whether AC Interest was an area source or a point source, it was impossible for the commission to determine if the emission reduction was surplus as the rules require. And therefore the certification was denied. So as I mentioned, Your Honor, an emission credit in Texas has a 5-year lifespan from the date of the emission reduction. So that deadline is part of the Texas's state implementation plan, which under the Clean Air Act we call a SIP, that's approved by the EPA. And it's in line with EPA's suggested timelines for emission banking credits under EPA's regulatory guidelines.
So based on, got a quick question, Council. So based on that 5-year period, he says is triggered from when the facility caught on fire. Is that the triggering point here?
That's right, Your Honor. It's when the emission ceases. So in this instance, it would be, according to the appellant's deadline, July 10th of 2010. And so it would have expired after 5 years.
So that would be July 31 of 15?
Of 2015, Your Honor. That's right. And what the...
Can I ask I'm sorry,
Yes.
Go ahead.
Sorry, Your Honor.
Yes, Adam. Sorry.
Oh, it looks like, I was going to ask a follow-up question. It looks like that the July 31, 2015 was about 4 months before this case was submitted to this court in the prior appeal. Did y'all mention this mootness argument to this court in the first appeal or to the Supreme Court after that?
No, Your Honor. At that time, the issue that went up on appeal in the Texas Supreme Court and to this court, Your Honor, was a notice issue. The appellant had served the commission what the state argued was 58 days and too late after the date. And so that was the issue that went up on appeal. And to my knowledge, mootness was not discussed at the other hearings. But Your Honor, I'm sorry.
No, go ahead. I'm sorry.
What I would say is at no time during the process in the courts of appeal, in either the first court, and also this case was appealed to the third court, in the Supreme Court, or any district court hearing, did the appellant request that anything be expedited. Now, I know of no doctrine that would allow judicial tolling in an instance such as this under the Clean Air Act. And I don't believe that appellant has provided any doctrine that would permit that. But certainly there are...
I can go back, counsel, just to where we were a couple seconds ago in terms of the mootness in the first appeal. I mean, did you all know that the case became moot when it was before this court the first time in 2015? I mean, it just seems to me that if you knew the case became moot 5 years ago, that maybe it would have been, seems like it might have been prudent to maybe let one of the courts know that you think the case had become moot?
That timeline could run out.
Right.
You know, Your Honor, I suspect that at the time, what we were thinking was that the notice issue would prevail. And perhaps in hindsight, that would have been prudent to notify the court. But certainly it's in the agency's rules, which, you know, appellant would have notice of. And so unlike a judicial doctrine or something where, you know, it's plain on the face of the rule, and the rules were cited to the district court in AC Interest's original pleading requesting these credits. And also, Your Honor, had AC Interest been able to provide the information that the TCEQ requested on any one of those 4 occasions, the timeline would not have expired. But much like the lifespan of something just like a gallon of milk, you can't unring that bell. You can't unsour the milk after the date.
So you said the timeline would not have expired under what circumstance?
Well, Your Honor, had he gotten the emission credit certified in any one of those 4 applications that he submitted, but the problem was each application he submitted had problems, and the commission was not able to tell from the data, and they were not able to provide the data that the agency requested over and over again. But from 2010, the first application was submitted in 2013. So there was a delay in that. There was a delay in service. So I'm highlighting that for the court. So the court understands that there would be no reason for us to delay, and certainly the TCQ to delay. That process proceeded there in the hope of helping AC Interest get their emission credit. But if they're not able to qualify for that credit and the credit can't be certified, the agency can't approve it.
Can I ask
And
you-
then
Ray, what is the policy behind having the 5 years tied to the event where the emissions go away as opposed to when the credits are certified? Because I guess that's the fairness issue is kind of tripping me up here.
Right, and I understand that. I do. As I understand, the 5 years is tied to the Federal Clean Air Act. What TCQ relied on was EPA's guidance documents to create an economic incentive program, and that's what an emission reduction credit is. The idea is that it's allowing, it's supposed to be an economic, beneficial way to help achieve clean air in a non-attainment zone. And so one of the guidance documents that the EPA discusses is creating these emission reduction credits, and that there are many ways to develop that, but that for states that would choose to have a statute of limitations on those credits, that 5 years was recommended because under the Federal Clean Air Act, 5 years can be a statute of limitations on some enforcement issues. And so TCQ's guidance is, or TCQ's rule is in line with the EPA guidance on that issue.
So the EPA guidance ties it to not getting the credits, but actually when the emissions were reduced, the triggering event for the credits as opposed to getting them certified?
The EPA guidance, Your Honor, is just a set of discussion basically on how states can create their state implementation plan. And so in that guidance, it talks about different scenarios. So I don't mean to imply that they borrowed word for word. The way the state implementation plan works for a state like Texas is we create our plan, we submit that, and that plan is how the state proposes to achieve clean air. We submit that to the EPA. The EPA reviews it to ensure that it is in line with the Federal Clean Air Act, and then it is approved. And so when we submitted our rule packet under our statute or our state implementation plan, that is the way the TCQ proposed it. And that was the initial emission reduction credit program began in 1993. I also want to point out to the
Let me ask
court.
you, I got one more question for you, and I apologize, counsel. Is
Not at all, Your Honor.
the time, the 5 year time period you mentioned earlier, part of that last question was the limitations period. Did I understand that correctly? That the 5 years is like a limitations period?
I think it's beneficial to look at. It is a limitation, but I think it's beneficial to look at it like a shelf life. Like I was mentioning, much like, something that had an expiration date, like a gallon of milk. It only lasts for so long. Also, I would point out that the emission reduction credit program at the TCQ is voluntary.
So it's a shelf life as opposed to a statute of limitations. Is that what you're saying?
I mean, that's how I would view it, but in the sense that it expires after 5 years, Your Honor, I suppose you could call it a statute of limitations.
Can I ask you a question about the process by which people obtain these credits? Is the normal case a kind of a planned shutdown where someone says to you in a year or 2 or 3, I'm planning to shut down this facility that will reduce emissions, and there's a planning process that goes into the event. So the event occurs in the future and they've already been in contact with you to talk about it. Is there anything in your rules or regulations that deals with the unplanned event that actually occurred here? I mean, the AC people weren't planning to have their plant burned down. So they didn't go through that 1, 2, or 3 year planning process that I think would be the normal case. It happened, and suddenly they were faced with a catastrophic event. Is there anything that you have in your rules that gives some kind of a leeway on that?
Your Honor, I know of nothing in the rules that provide any sort of force majeure limitation or anything such as that. I think the delay in this case was that AC Interest was debating whether or not to rebuild their plants. And so in that time period, rather than submitting and requesting for that emission credit in 2010, they chose to wait to decide how they wanted. And it just took a while to get to decide whether or not they wanted to seek a new permit and to provide that information. But I want to highlight for the court a couple things. Again, as I mentioned, the program is voluntary. There's no right in the state of Texas to emit. We have certain things, permits that allow some types of emissions, but this is a voluntary program, and it's to say that whether or not I'm not certain whether or not AC Interests would have even been able to meet the requirements to get those credits had they been able to properly seek that to get the certification from the agency.
Are you aware of any, under either this scenario of this case or any other scenario, are you aware of any statute or rule that would toll or abate this 5-year statute of limitations that we were talking about?
Your Honor, I am not aware of any. I know of no doctrine that would allow judicial tolling in a case like this. And if this court were to submit the case back to the TCEQ, there would be nothing left for the TCEQ to do because those credits have expired. And I understand that that is unfortunate for AC Interests, but that is what the rule states, and that is what the agency's policy has been, and that's how the rule works, Your Honor. I would quickly touch on the takings issue that AC Interest raised as well. Your Honor, you can't have a taking of something that you have no ownership interest in. They were never awarded the certification in this case, and therefore there would be no way that there could be a taking. Also, under the Texas Administrative Code in the same set of rules, Your Honor, the rules specify that there is no property interest in an emission credit certification. So this is the very essence of a case that shows mootness, Your Honor. We would ask that this court affirm the holding of the district court and dismiss AC Interest's appeal for mootness.
Thank you, Ms. Billings-Ray. Are there any further questions from the justices?
No. Thank you.
Thank you. We'll turn it back over to Mr. Smalling for his final 4 minutes.
Thank you, Your Honor. The EPA guidance has a range of between 5 and 10 years for the length of the emission credit life. In fact, the TCEQ rule states that if the emission credit was applied for before 2001, it can live for 120 months, which is 10 years rather than 5 years. So there is up to 10 years in the EPA guidance. Also, to answer the question about the 4 times it took to submit the application, resubmit it, and so on, we believe the TCEQ is biased against granting area sources such as AC Interest emission credits, and this isn't without justification. This statement: on or about November 19th, 2014, the same day as AC Interest denial, Mr. Steve Hagel, then the Air Deputy Director at TCEQ, denied emission credits to not only AC Interest, but 5 other area type sources. On this same date, Mr. Hagel forwarded a proposed emission credit rule change to the commission, which, if the commission had adopted it, would forever ban area sources from obtaining emission credits. In June 2015, this rule change was recanted by the commission, in part because of comments and objections by the Texas Chemical Council and others.
Mr. Smalling, can you direct me to where in the record you're getting this information?
It's in the proposed rule changes that on or about, it's in the TCEQ's rule, historical rule, records back in 2014, 2015. It's in the proposed, the rule proposals for 101, chapter 101 in late 2014. And then they had an adoption in 2015 that struck out this provision that banned area sources.
I got a quick question, Council. Is go back to the mootness issue that we were talking about earlier. Do you have any cases or authority that addresses the mootness context for statute of limitations outside of attorney malpractice cases where it's been applied, or in an equitable context, for example?
Well, is let's see, Cabot versus Pollard versus one of the three, Pollard versus Hanshin, Hughes, and Cabot versus Amsler. At least one of those three was not related to attorney malpractice, but I don't have exactly which one it was, but.
Thank you, Mr. Smalling.
Thank you.
Are there any other questions from the justices this time?
No.
If not, I will thank both Mr. Smalling on behalf of the appellant and Ms. Billings-Ray on behalf of the appellee, and to say that the case of AC Interests LP, formerly American Coatings LP versus Texas Commission on Environmental Quality, has now been submitted, and we thank you for your arguments. They're all very well done.
Thank you.
Thank you, Your Honor.